we're happy to launch the webinar Perspectives for Corporate Climate Litigation in Brazil, organized in partnership with the British Institute of International and Comparative Law and the Law, Environment and Justice in the Anthropocene Research Group, better known as JUMA, from the Pontifical University of Catholic University of Rio, PUC Rio. Before we begin, I'd like to present some important information. This event will feature Portuguese-English simultaneous interpretation by interpreters who are graduates at the PUC Rio Conference Interpreter Training Course, Angela Sanchez and Claudia Miller. And I want to thank the interpreters and Professor Rafaela de Felipe Esquental, the course coordinator, for their willingness and indispensable assistance in making this event a success. If you want to hear the translation, just click on the globe on the bottom right of the Zoom screen and follow the step-by-step instructions sent in the chat. I'm Danielle Moreira. I'm coordinator of JUMA, and along with the researcher Garrido, I share the reporting for Brazil and the Global Perspectives on Corporate Climate Legal Tactics project led by the British Institute of International and Comparative Law, and coordinated by Dr. Ivano Alogna, who will soon explain to you the details about the project and some of the results already achieved. To give you some context about this event on corporate climate litigation in Brazil, I'd like to highlight very quickly how Brazil presents itself in the global scenario of climate litigation. We all know that from a global perspective, the total number of climate litigation cases has increased significantly, especially since 2015, the year of the Paris Agreement was signed. In addition to the significant increase in the number of cases, the number of jurisdictions with reported climate litigation has also increased. And in this process of geographic expansion, cases from the global South have gained visibility, and Brazil is part of that. With 120 climate cases currently registered in climate litigation platform in Brazil, we are among the countries with highest number of reported climate litigation cases. According to Columbia University Sabin Center for Climate Change Law database data from yesterday, the US has 1,884 cases, Australia 135, the United Kingdom 127, and Germany 61 reported cases. One important aspect that has been observed is an increasing cases against the private sector. More and more cases are being brought against corporate players, with an increasingly wide and complex range of legal arguments coming from the most diverse areas of law. Our goal here today is to look at Brazil and understand some of the possibilities for corporate climate litigation in our country. Researcher Carolina Garrido will speak a little bit more about the importance of looking at Brazil in the debate on corporate climate litigation. But before that, I would like to invite our dear partner, Dr. Ivano Alogna, coordinator of the Global Perspectives on Corporate Climate Legal Tactics project, for his opening speech. I really want to thank him immensely, both for the partnership and for the important studies he has developed on the subject. Dr. Ivano will be presenting in English. So for those who want to hear the translation into Portuguese, you need to select the language on the global icon that appears on the bottom right of your Zoom. Dr. Ivano, you have the floor. Thank you.
Thank you very much, Danielle. So I just share my screen. Can you see it? Okay, so welcome everyone. I would like, first of all, to sincerely thanking Danielle and Carolina for their exceptional work in organizing this event. Their dedication and efforts have made today possible. I also would like to extend my gratitude to the distinguished speakers and the participants who have joined us. So let me start with a few words about the project. You can scan the QR code embedded in the slide to access the project's webpage. This is a project we started in September 2022, a comparative law project to study the possible avenues, hurdles, and prospects for this kind of litigation, taking stock of legal experiences and tools in the different countries around the world to discuss innovative possibilities. So in March this year, we presented in London the fruit of this journey, what we call the Global Toolbox on Corporate Climate Litigation, which is an evolutive, collaborative, and open access platform designed to keep NGOs, companies also, government entities, local communities, and legal professionals with a diverse set of instruments tailored for corporate climate litigation. So the toolbox tries to level the playing field for everyone involved in climate disputes to drive faster, more efficient results in critical cases around the world. So you see here our project goals to map corporate climate litigation globally, to catalog pivotal cases and learn from experience in other legal fields, to foster strategic thoughts, which might be helpful in litigation planning and also in achieving more effective action, and of course, to motivate corporate change through raise awareness of litigation risk. This is our project working group. We have integrated inside from 17 national reports and expertise from a core group of internationally recognized experts from both the Global South and the Global North. Here you can see some prominent experts in the field from every continent. We have Justice Preston from Australia, Professor Michael Gerard, the director of the Sabin Center for Climate Change Law at Columbia University, Dr. Ivano Alogna, the Minister of Justice in Rwanda, Harish Salve, who is the former Solicitor General of India, and also, for example, Professor Michel Prior, the father of French environmental law, and Eric Keedy, who I'm sure you know, the director of the Climate Accountability Institute. So they are all part of a wider international expert group with more than 200 experts worldwide, ensuring a rich tapestry of perspectives benefiting from the wisdom of the judiciary, legal practice, and academia, each one of them having contributed to our work during national and comparative workshop, public events, through discussions, consultation, and reviews of the different sections of the toolbox. So as this part of this project, we created the Corporate Climate Litigation Platform, which, as you can see here, is composed of 3 parts. So we have the CCL resources, a rich collaborative repository of literature and references in this field. Then we have a user-friendly AI-powered database, which will be developed in the next months in collaboration with Climate Policy Radar. And then we have a comparative laboratory to delve deeper into the challenging issues of corporate climate litigation, what we call the CCL Toolbox. So this is just an idea. CCL Resources, as this literary repository, is being established, is growing with the support of our international expert group members. And we have references to books, journal articles, reports, webinar, podcasts, and blog posts in this field. So I ask you to check this out when you have time. The CCL Toolbox is the third part of our platform, as I said, where you find the global toolbox, the 17 national reports already published online, and also the national conferences and regional summits recording and materials. You will find also this later. So please feel free to download the 17 national reports, including the one from the amazing Brazilian group that is part of this conference. We have recently added the executive summaries in both Brazilian, Portuguese, and English, thanks to the outstanding work of Danielle and Carolina. And here you see some screenshots of the Global Toolbox in Corporate Climate Litigation. Our analysis is founded on 3 axes: the causes of action, the procedures and evidence and remedies. And you can see on the right end of this slide, we have explored the possibility related to the most critical causes of action to be used in this kind of litigation. We have from climate environmental statutory provisions to human rights, very important, especially in this moment, tort law, many others, consumer protection law, contractual obligation, and so on and so forth. And also, we explore the most relevant procedures and evidentiary elements in this kind of litigation, including legal arguments and defenses, the issues of justiciability, jurisdictions, group litigation apportionment and cost, among others, and of course, the possible available remedies. This is quite exciting. As you can see on the right part of the slide and on our website, the Toolbox structure offers legal models, authoritative references, and strategic comparative insights. It is important, I always say that, to highlight that this Toolbox is not merely a platform, it's really a testament to global collaboration. As you know, legal systems are varied, but our challenges are shared. And so I finish with this last slide. The Global Toolbox is, as I said, a dynamic, evolving platform set to release its next update in early 2025. And it's guided by ongoing dialogue with our expanding international expert group. It grows weekly, incorporating diverse expertise. And this evolution is enriched by 5 regional summits. We will have the next one, the American one, in February, and 17 national conferences, such as this one, held as online or hybrid events with partner universities and institutions. These events, supported by our outstanding national rapporteurs, engage key stakeholders to test, refine, and enhance the toolbox. Thank you all for your attention and for being here today. I look forward to the rich discussion ahead and the valuable insights each of you will bring to this event.
Thank you, Ivano. It's a beautiful project. I thank you for presenting it and for our partnership. And now we're going back to the presentations in Portuguese. So I will remind you that if you need the translation in English, you can click on the icon. And I'll give the floor to Carolina Garrido, that is our researcher on global climate. Thank you. Good morning to all here in Brazil, and good afternoon to whoever is elsewhere. So I would like to close our opening talking about the importance to look at Brazil when discussing corporate litigation. As Danielle has already said, Brazil is one of the jurisdictions with most cases of climate litigation registered in the world, with 120 cases analyzed and proposed. And on the other side, Brazil is one of the 6 largest emitters of greenhouse gases in the world. Here in the country, we have a very specific profile in which the main sector to contribute is land use with 48% of national emissions, followed by the agricultural sector, which contributes to 27% of the emissions in the country. So we do have a very specific profile and that contribute to the severe impacts from climate change, including floods, droughts, forest fires, and biodiversity loss, which disproportionately affect indigenous communities and vulnerable groups, especially considering the impacts that affect unproportionately the indigenous communities and vulnerable groups. The country has a robust legislative framework which encompasses environmental law, human rights, consumer law, corporate law, competition law, and civil law, offering legal tools for corporate litigation. I'm looking here specifically for that in the 120 cases in the platform, several analyses from our research group show an increase in these cases in the private sector, including logging, energy, and mining companies accused of promoting or contributing to deforestation and failing to comply with environmental regulations. It's an instrument of environmental liability, and we consolidate the role of courts in the Brazilian climatic scenario. Our national report includes these three central themes: the causes of action, highlighting the main standards that are used or that may be used in corporate litigation. And we're going to talk a bit more about this today. In the second theme, the procedures and evidence, examining procedural aspects such as standing, jurisdiction, class actions, and the challenges of providing and calculating climatic damages. And in the third one, the measures required. So addressing aspects such as pecuniary compensation and non-pecuniary measures, such as compensation for damages and restoration of degraded areas. In addition, it highlights paradigmatic cases on the subject, and also other areas that could bring some parallels to the climate discussion. The report was published in February 2024, led by Dr. Caio Borges, and included the participation of Maria Eduarda Segovia, that is here today, talking about some relevant topics in this research, Juliana Avila, and myself. We have this research group that was responsible for the report. It was also a result of interaction with members of the Brazilian group of experts, many of which are also here today as lecturers. So it's going to be very good to go on with this event. Today, we are launching the English and Portuguese versions of the executive summary of this report, prepared by Danielle and myself to help disseminate this important research. And we have organized this event to discuss some of the topics, the main topics that have proven to be the most relevant during the course of this research, such as the access to justice, the relevant legislation, corporate law in regards to climate litigation, environmental licensing, and the impacts of corporate actions on the rights of indigenous peoples. So without further ado, we can give the floor to our first panelist, Alessandra Lehmen, professor of the post-graduation of Caxias do Sul. She is a lawyer qualified in Brazil and New York, president of the Environmental Law Commission, Brazilian Bar, Rio Grande do Sul, postdoctoral laureate, PhD of the Federal University of Rio Grande do Sul. So I'll give the floor to Alessandra. Thank you, Carolina. Can everyone hear me? So first, I would like to thank for the invitation and thank Professor Danielle, who's been developing essential work on climate litigation in Brazil. I would like to congratulate the work of the researchers, Danielle, Carolina, and the other members of the team. It's a pleasure to have Ivano Alogna here, who has an outstanding performance, and I was fortunate to be able to read his work, and I highly recommend it. And due to time reasons, without further ado, I'm going to talk to you today as Professor Danielle asked me to talk about cross-cutting aspects, and as Carolina just mentioned, other aspects that can be articulated in the scope of law as viabilization instruments of corporate climatic litigation. So how this phenomenon of corporate climate litigation happens around the world, and especially how it can be determined from certain legal models and legal rules, from general experience, to think ways that these theses and arguments can be applied in the Brazilian scenario. So to do that, I would like to reinforce one of the reasons that we've been seeing this adaptation phenomenon. The first thing that I need to say is that climatic litigation generally is developed in national courts. We don't have an international court specialized in these issues, especially with non-government actors. And in general, it is in general, we take these issues to national courts.
I brought this data to you, mapping the results regarding climate litigation globally. So we see that we have mostly favorable results that have to some extent accepted the thesis of the authors. Success breeds success. Since climate litigation is an issue of uh, is an issue that goes beyond the legal area, it has these characteristics of really ensuring some governance adjustments going beyond what we wish for concretely in each cases. Based on my practice as an attorney, I've been mapping, just for didactic purposes, some possibilities and results based on that. The title of this slide is Some Possibilities of Corporate Climate Litigation. And we know that this scenario evolves constantly. So from the progress of the standards and regulations, we notice the evolution of these areas. We have one specific issue regarding litigation against companies. So we have always new arguments used in the cases. So very quickly, since we don't have much time, some of the possibilities I have mapped, as I mentioned, just for didactic purposes, are cases based, for example, in the idea of outsourcing of emissions, the idea that by those companies that are relatively cleaner and generate a smaller climate impact on their jurisdictions, but through their transnational activities do not follow the same profiles. And the emissions of greenhouse gases are questioned not for the whole company, but also regarding specific projects. We have cases of accountability for climate damage. I imagined the speakers who are going to speak after me in Brazil might address this topic, but the process, the procedures that aim for accountability for climate damage have been increasing in Brazil. In the first wave, we had cases that wanted the obligation to do governance adjustments. And now with advancements of science, especially the science of attribution, we have advanced towards the accountability for climate damage in Brazil. We have some climate cases, some other ones that are not specifically investing in Brazil that regard access to justice based on Roma II agreement, aiming at substantive law of the country of damage for damages caused in other countries, including Brazil, will have a tendency that I imagine is going to intensify after the results of COP29 of uh, actions against transnational companies. We have here financial institutions with different financial products. We have, for example, a case involving the National Bank of Belgium that referred to the acquisition of sector bonds from the National Bank of Belgium with carbon intensive sector bonds for the European Union. We have the case against a commercial bank regarding the financing to carbon intensive sectors in a country with a history of human rights issues. We have the Brazilian case of BNDES, the Brazilian Development Bank, and BNDES participations. That was a case mentioned by the special rapporteur report in the UN against an investment bank, but not related to its financing activities, but to its portfolio of equity investment in carbon intensive sector. We have the case of DECA Bank, an investment bank in Germany, a case of greenwashing also related to taxonomy, related to sustainable investments. We have several results of that, especially in the scope of the Green Deal European in 5455 program with the strengthening of regulations used by the autonomous European Union, and they generate effects into other countries down the line that provide the possibility of questions through climate litigation. So we have the case of Casino. We don't have to get into detail that, but it's a very known phase based on this idea that both some countries in the European Union and the European Union as a whole have regulations that have effects beyond their borders and that generate effects that go beyond the original jurisdiction. And the effects of that can be questions due to the character. We have very short time, so I'm going to go very quickly over this slide that shows what I have just mentioned. We have many other regulations, but maybe the one that has more effect or will have more effect in terms of corporate climate litigation is the European Union deforestation regulation that has very important impacts for Brazil that it exports commodities. The European Union Mercosur trade agreement that will generate effects for the private sector. We have the other protection schemes that protect frontiers such as the CBAM, and we also have European, French, and German regulations that set vigilance and due diligence duties, such as the CS3D, triple D. And I believe this is going to have a very important impact for corporate climate litigation in as much as it requires the companies comprised in it to create a climate transition plan that is compatible to limiting to the increase in temperature to 1.5 degrees Celsius. And what I want to say that is that if we had litigations under the CS triple D, we would have other results for the procedures we have had recently. And finally, I want to call your attention to the transnational corporate climate litigation that end up involving material arguments and involving more than one jurisdiction due to the trans-border characteristics. I can share this material with you later, but here I have I mapped the most recent regulations regarding that, and I think it's important for us to take a look at all these regulations because they will have impacts in corporate climate litigation, including in Brazil. We also have cases involving the duty to inform shareholders and the market in general. We have cases for liability of management agencies members, such as the case of Shell in the United Kingdom. We have possibilities in the capital market through investor shares with questions regarding fiduciary duties. So we have institutional investors asking questions about climate issues, and we have other possibilities that we have mapped in a recent study regarding other possible paths for procedures in Brazil involving shareholders. Since I have very short time, I won't be able to get into detail for that, but this is a possibility worth looking at. We also have the corporate climate litigations involving subdivisions of washings with financial products, advertising, and more recently, corporate climate litigation for greenwashing regarding carbon offsets and tourism sector. These are also sectors that we have been monitoring. We have litigation started by the company. Not all corporate climate litigation is for climate. We have arbitrations for ISDS. Brazil is not part of that, but that allows the start of an arbitration procedure by an investor. It might apply to a more progressive company, but it affects the rights of investors. And finally, what we call the scope for that it's not properly called that. That naming is improper, but that applies to other sectors, including consulting companies. We already have the case of Portland against oil companies. That includes for the first time a consulting company as a defendant. And we also have, in the scope of law, we have more initiatives considering the impact of the profession as in our path for regarding global emissions. And one of these examples is Legal Initiative 1.5 that comes from companies in the UK. And now moving towards the closing, we have a growing possibility of disaster litigation regarding the climate. Not only all disaster litigations are related to climate, but we have all these impacts that we have suffering. And we have witnessed a growth in disaster litigation that in the United States is structuring this way. We have states of the union. We have a different federation structure, different from Brazil, but we have procedures involving oil companies on different bases seeking reparation for climate impacts. So we had, we had the case of Oregon, we had the case of California, and result about that regards following that trend, we had in Michigan a public call for private lawyers to act as special assistant attorneys general with the specific goal of litigation regarding climate change impact reparations. We have some cases already in Brazil. Imagine those who are going to focus on Brazil will probably talk about disaster litigation. We have a very very specific example, the one regarded Mariana, aimed at adjustments in governance and prevention and results impacts of disasters, and very briefly, really moving towards the closing. I'm not going to get into detail of all that. We have addressed that in the national report, but the message I want to leave you with today is that we have a huge range of arguments that can be used as for the basis of climate litigations. We have the Paris Agreement and other treaties, we have constitutional basis, we have climate regulations that may be specific or being other laws. For example, the Brazilian Forest Code, we have due diligence regulations that generate obligations that might be under analysis. We have issues related to consumer law and product liability, financial institution liabilities, the disinformation and misinformation, issues related to corporate law and fiduciary duties in the states in general. The United States, we have a lot of actions regarding torts and nuisance. We have actions related to duty of care and vigilance, companies and human rights. In New Jersey, we had an argument, an innovative argument regarding racketeering that had been used for organized crime and was used for climate litigation. And finally, voluntary commitments as from the point companies adhere to certain climate information release, this standards, they can be under analysis, under scrutiny, even through litigation. And to close everything I wanted to say with this final slide, I think it's very interesting for us to observe that climate law and climate litigation are really good for using this transnational litigation with transitions to circulation of models and climate translational. Like I like this Schaefer and Bodansky quote that says that the migration and impact of legal norms, rules, and models across border. This is what we witness regarding climate, because we really have this narratives that are organized on legal basis and science basis. This is what I wanted to share with you today. Once again, thank you. I'll leave you with my contact information in case anyone wants to get into detail in any of the points. I'm always available. Thank you very much. And I give the floor back to the moderators.
Thank you, Alessandra. It's always very good to hear from you. I think you brought an important scenario, bringing the trends and the current status. So it's very good to hear you. And I thank you for being able to squeeze in participating in our event. Thank you so much. I'll continue with our event, and then I would like to invite Maria Eduarda Segovia. She's going to talk about relevant aspects of the climatic Brazilian legislation. She is a lawyer, graduated from PUC-Rio, with a focus on state and society, and holds a postgraduate degree in environmental law from the same university. She's a researcher and specialist in climate regulation. She's part of Brazil's expert group for the BIICL and contributed to the development of the report on corporate climate litigation in Brazil. She worked as a junior legal analyst in the Climate Law and Governance program at CPI Brazil and was a researcher in the law, environment, and justice in the Anthropocene group. Additionally, she served as the Brazilian rapporteur for the Global Climate Litigation Network at the Sabin Center. Thank you so much, Danielle. I'm going to try to speak slowly to help with the translation, but sometimes I end up speeding up my pace. I'm Maria Eduarda. I'm a researcher and lawyer specializing in environmental law and climate change. I would like first to thank for the invitation to talk about this topic, which is so complex. And I would like to thank Professor Danielle and Biko. I'm very honored to share this panel with all those great names. And I think it was really interesting that Alessandra spoke before me because she talked about the legislation in itself. And it's going to be interesting to see the contrast with what I'm presenting here today. So we're going to talk about environmental climate and legislation, which is complex, and it's hard to talk all about it in 20 minutes. But I'm going to focus in the BICO report. And we can map all the ways we can work. So as it was very well presented in the report and today by Professor Danielle, there are different ways that can be used in corporate climate litigation. We can talk about civil law, environmental law, consumer law, human rights, and business law. There's a lot of potential because these are topics that talk to each other. I'm going to talk a bit about the reasons of environmental law, and all of these branches of law, they relate to each other. So we can talk about social environmental protection, and it is important to remember the construction of arguments having in view the Brazilian legal system, the environmental law, and this is why we're going to focus in this presentation, having in view, as I said, the reason to be of law. It is a way of defying traditional legal tools. So we're dealing with the complex problems of climatic and environmental crisis. And as I usually say, mention what Danielle says, that environmental law is considered a subversive area of law. There is a great potential to environmental law when we're talking about climate change. We're talking about social responsibilities in promoting climatic justice, and we've seen that in the Brazilian climate actions. I always think it's a bit important to bring some of the evolution of the Brazilian environmental law so we can understand how we can use these regulations and principles I'm presenting in a more fluid way. How can that be used in our legal system? I believe that most of you are familiar with the declaration, the Stockholm Declaration. It was very important because it rose the awareness of the impacts on society related to environmental issues. So it brought this notion of what environment is and how it relates to human rights. In 73, Brazil created the Special Secretariat for the Environment. And there were some important legal marks, especially 81, the National Environmental Policy, which is one of the main regulations I'm going to discuss here today. And it has a more systemic and holistic perspective, defining environment, including ecological, social dimensions, not just a set of natural elements. And of course, with the Brazilian redemocratization, with the federal constitution, that has elevated the environment to a constitutional right, and it established the right to ecological balanced situation. So to focus in legislation now, I try to bring topics that as the report highlights, we have the forest code, the national preservation system, the environmental crime law that was mentioned by Alessandra, and all these regulations, they are specific and depends on the case. So I need to be brief, but I'm going to try to talk a bit about issues and theses that go through all of it so they can be more mobilized and worked in climate litigation. So we can talk about Article 225 and also about the social environmental function of property, which is one of the most important when we're talking about actions against companies. We have an article that talks about economic empowerment. So we're talking about environmental protection and environmental justice. So in the Article 5th, item 23, we talk about that property, social, environmental function in the federal constitution. So it cannot just, it needs to meet some social environmental purpose. We also have, that is super important, the human right to environment that is ecologically balanced, especially in Article 225. The Supreme Court has already recognized it as a fundamental right, and that we not only have this right, but we have the duty to protect environment. So all society and the private sector has to protect the environment. It's being very used in the Supreme Court. And a very important question is this of civil liability. Whether it's direct or indirect.
So it will occur regardless of the desire to do that, to generate damage or omission, or the causality issue. Going a little bit beyond what regards objective environmental civil liability, the academy and we have the theory of integral liability. Some of the issues are not accepted when we're talking about civil liability, environmental civil liability. The mere existence of risk that that activity generates, that player may be considered held liable regardless of the impact existing or not. So this is something that has been greatly debated regarding environmental civil liability, because due to this, the difficulty in identifying exactly how flexible you have of identifying causality and the actions, but it's still the environmental civil liability is still an issue that is growing a lot here in Brazil. Another of the important issues regard the national environmental policy in Brazil regarding possibility, and the definitions have also been very important for the development of environmental law here in Brazil. As you can see, this is the third article of the National Environmental Policy. It brings a broader concept of polluter that says that a polluter can be directly or indirectly responsible for the causing activity, but there are other important concepts regarding pollution that have to do with health and well-being and safety, and everything that influences the internal issues. So all that is included in the definitions of the National Environmental Policy. And I imagine that when you're talking about reparation due to environmental damage, we have the idea of full reparation for climate damage. And that also brings what is in the Brazilian Constitution and the federal law in Brazil that understands that the reparation has to be full. It has to address individual damage, collective damage, material damage, and moral damage. So as we say here, it can be material regarding pecuniary, but it can also be moral damage. That can be collective, individual. So there is a broad range of possibilities for reparation for damage, especially due to the complexity of the environmental damage itself. So the full reparation is something we see very often in environmental, and also is related to the environmental civil liability. Another issue that is very important regards the environmental licensing in Brazil. I'm running out of time here, so I'm going to try to move constantly. Please then don't speak that fast due to the translators. If you can speak a little bit slower, thank you. I'm sorry, I tend to speak very fast. But environmental licensing is something that Luis is going to address heavily when he talks about specific cases, but it's important to consider that if you talk about the breadth of the environmental impact that needs to be analyzed in the studies, has to consider the emission of greenhouse gases. And Luis is going to talk a little bit more about that further on. I'm not going to talk too much about the legal thesis because they are end up being self-explanatory, but these are the main ones used for climate cases, and they are very important when you consider full reparation and interpretation of all the regulations that I have mentioned before. I like to highlight this decision by our Supreme Court that regards the flexibility of causality. It's a controversial decision, especially when you talk about the obligation to do, and it says that everyone is, especially when you're talking about indirect polluter, but it's important for you to understand the liability of institutions. In the national environmental policy, we already have that determination. We have some other determinations in that, but this decision by our Supreme Court mentions that we can also the financing for actions that cause environmental damage can result in liability to the actor. And now regarding climate legislation and its instruments, the future of that is the National Climate Change Policy Act. It is involved in the economic and social development regarding the emissions of greenhouse gases, adaptation measures, the relevance of the participation of society, the private sectors, especially vulnerable groups, and it's under review right now. We have some bills in Congress to review and update this regulation. So this is something important for us to monitor because that determines our climate policy, and it determines some main instruments regarding climate, the climate fund and the climate plan. The climate fund is aimed at plans that reduce emissions and adaptations, and it has recently been one of the constitutional climate actions here in Brazil. I brought two parts of this decision here that our Supreme Federal Court has highlighted. First is the thesis that says that it is the executive branch has a constitutional duty to operate and annually allocate resources from the climate fund for the purpose of mitigating climate change. We had funds that were not used in the DPF 708, if I'm not mistaken, and now move connected to the Paris Agreement, it's become more relevant. The Paris Agreement is addressed here in Brazil, but our Supreme Court has acknowledged the superlegal nature of the Paris Agreement because of its connection to human rights, especially because of the right to a balanced environment and well-being. The Paris Agreement seeks environmental protection so it can be can receive, or we can attribute a superlegal nature to that. I'm going to very quickly go over the Brazilian greenhouse gas emission trading system. It's very relevant to how the Brazilian policies are going to be. It is related to recently sanctioned areas, and it brings two main areas that are mitigation and adaptation, and there are sectorial plans developed for mitigation and adaptation, and they are going to define the behavior of the sectors regarding the emissions and adaptability. It is it is being elaborated right now, and after publish, it will probably have to be mandatory, and we'll probably see some political climate movement in after the publication. So I really recommend you follow that up. And recently we have also the approval of this system that regulates the Brazilian carbon system. It's waiting for this as sanctioned by the president. It's very much used in climate litigation here in Brazil. It's another thing for us to monitor because climate sector in Brazil, it's really busy right now, and we need to keep an eye on everything that is happening. It's my last slide, I promise you. I brought some debates that we've been having in Brazil. Alessandra already talked a little bit about the difference between environmental law and climate law. Is there a difference? Are they the same thing? There's a strong academic movement from the academia in separating those two branches of law. But climate law is inserted into environmental law with the idea of using all these laws I mentioned from environmental law in the climate debates in Brazil. I believe this is a debate that is going to reflect in environmental actions and the decisions that are going to be made depending on the bias of the plaintiffs. In Brazil, we already had 80 actions that we are now gotten to more than 100, as Danielle and Alessandra have mentioned, and Danielle and Carolina have mentioned. And I got all this data from the report from Brazil. I recommend you read it. It's very interesting, but it's focused on data up to March 2024. So there are some actions that probably had not been mapped in the past. But what is important for us to focus on is Article 225, which is the one that has more mentions in the litigations we see. It's present in 74 of the litigations, not only the Article 2025, but also the National Environmental Policy. And what we see and these mentions show that this is going to be heavily used in climate litigation because they don't focus specifically on climate change, but these are the two most used regulations in this area. And very quickly, for any one of you who want to understand better the panorama, we have this new protocol regarding environmental actions that brings specific scenarios for calculation of climate damage in Brazil. There was a debate on how we should calculate that or could calculate that, especially in the legal system. This protocol brings some data and information regarding that. So for those who want to explore and understand the climate liability actions, I recommend you read that protocol. This is what I wanted to say, and I apologize for going a little bit over my time. Thank you. Thank you, Maria Eduarda. Thank you very much for your presentation. And I'll take the opportunity to mention something I was going to mention only at the end. But Maria Eduarda mentioned the report we published in June that analyzed the 80 lawsuits that was in the system until March 2024. Right now, we have 120 lawsuits. We are elaborating a bulletin, which is a simpler document, but that is going to be launched before the end of the year. I don't have the exact date, but it's will bring a better picture although not in detail, but it will give you a better picture of the Brazilian scenario with the cases registered in the platform up to October 2024. And I can confirm what Maria Eduarda has mentioned. We had a significant increase of civil liability for climate change. And when you talk about environment, so climate damage, you can have a feeling of my opinion of climate law that is a specialty of environmental law and not an autonomous branch, but a specialty in it. Once again, thank you, Maria Eduarda. And without further ado, I'd like to call for his presentation my dear friend Gabriel Wedy. He's going to talk about access to justice and process instruments for corporate climate litigation in Brazil. Gabriel is a federal judge. He's a professor at the postgraduate program and law school of the University of Vale do Rio dos Sinos and the Superior School of Federal Magistracy. He holds a postdoctorate, PhD, and a master's degree in law. He's a visiting scholar at Columbia Law School, and he's a member of the IUCN, the World Commission on Environmental Law. He's the vice president of the Institute of Law for a Green Planet and a former president of the Association of the Judges in Brazil. Once again, I want to thank Gabriel for the availability to be here with us participating in this event. I know he has a very busy agenda, so I want to really thank him and give you the floor. And this is a question, it's a request I make for myself that you speak slowly to make the job of our translators easier. Gabriel, you have the floor. Well, my dear friend Danielle, it is a great joy to be here at JUMA. I was observing the quality of the researchers that spoke before me, and I have followed the JUMA since it emerged, and it has developed very positively. It is one of the most important centers for data for Brazil, and I recommend it to all my PhD students, especially thanks to the precise analysis and translation of the cases, both from abroad and local. We had some important observations by Alessandra and other speakers talking about corporate climate litigation case by case in this international level. And then we had a very important, interesting presentation regarding procedural instruments to be used in climate litigation. Yesterday, I was giving a class for judges in Rio talking about climate civil actions. And this has grown a lot in the last few years, which shows that our Supreme Court has several specific cases on climate law. One of them regards Fundo Clima and the Amazon Fund, Climate Fund and the Amazon Fund. And also everything regarded to forest fires in the region of Pantanal, which is very serious. Our Minister Flávio Dino has focused on that. We had a great debate this week in the Federal Justice Council, where they are creating a new protocol regarding actions, procedures, and quantifying damage. So all this is going to be organized by Minister Antônio Sérgio Herman and Paulo Sérgio Gomide. They are very much concerned with all that and with bringing new references. based on the journey that we had with great participation with dozens of federal and state judges, participation of ministries, and that is all very important because the decisions about these cases since Constitutional Amendment 45 will end up in the Supreme Court in this area. So I switched a little bit what I was going to speak because I was going to mention several cases that Alessandra has mentioned. I was going to mention about jurisprudence and our Supreme Court. I believe we have the most advanced jurisprudence, and I agree with our ministry when he says that we acknowledge here the liability in climate impacts, the objective liability for full reparation, and the liability of the state regarding everything that comes from French justice. And how we have addressed even our ministry, Alexandre de Moraes, in recent decision at the federal Supreme Court decision that he made. There was great debate at that level regarding the application of regulations related to consumer law and changing the responsibility, switching the responsibility to the polluter. And now we have approved 2 decisions in that sense in the first environmental law meeting of our Supreme Court. Now, moving a little bit, the topic of our conversation I'd like to talk about what happened in the United States in the beginning of 2024. They have created rules to inform investors regarding rules and risks of impacts, and that has been generated by the states. And I hope that doesn't have that big of an impact in Brazil. But they have approved this new regulation. The Securities Exchange Commission has approved that. Of course, there were protests from many politicians, especially the right wing. When we debate climate law in the States, it's important to talk about that. And the Security and Exchange Commission has created new rules on how companies should release climate risks and exact amount of emissions of greenhouse gases they have. But there are less demands for corporations. At the end, they approved of smaller requirements and sanctions compared to the original proposal they have made. I have monitored that, especially through the New York Times and other materials. And these new rules require the corporations to inform investors about their greenhouse emissions, about the commercial risks they face, such as floods, increases in temperatures, and the companies need to inform the risk of climate disasters. There was a strong, broader proposal, but it faced great lobby and reaction of the fossil fuel industry. We know they are very much present in Washington. They work a few blocks from the Congress in Washington, D.C., but the main difference regarding the original proposal is that the large companies would have to release not only the amount of emissions that would generate an increase in temperature for the planet, but also the emissions produced in the entire value chain. In international law, that applies to all parts, all services, purchases, vendors, and even the way the consumers are going to use the products, in fact, that generate emissions. And also how you're going to discard these products at the end of their life. So the value chain can also have an impact. I read an article by a professor from Columbia University and another one from Bochum, and this is a negative reality. And the same applies to emissions that are understood at pollution. They have been debating greenhouse gas emissions and if it is pollution or not since 2007. And it has been considered pollution since the case of Massachusetts against EPA and also West Virginia recently. And it has not, that case has not replaced the case of Massachusetts against EPA. But the main requirements regarding releases have been suppressed. But anyways, corporations have to release the emissions they produce directly, but only the companies need to consider this material and significant emissions in their financial results. And it's an evaluation that leaves room for corporations to maybe change their data. That applies very heavily to oil companies. And this was kept under the rug for a while. And another thing, and smaller companies are exempt from that. Another change is another one. We had a proposal that required all companies with shares in the market, all public companies, to release the information that is not in the Security Exchange Commission rules in the States. And of course, that would be an important measure, considering what has been just released, Danielle, 3 weeks ago, the Emissions Gap Report 2024, and the data in that report are important. They are even scary and without wanting to cross any alarm here. But they also removed from the final proposal made by the environmental branch of the Biden government, companies need to declare their climate expertise to their board of directors. That would be important because climate change should be addressed by board of directors of large corporations, but they have maintained the directives of companies and the obligation to mention risks regarding climate change, risks to properties on the coasts, such as hotel chains, real estate developments, especially due to the increase in the sea level. So all this carbon intensive sector of the company and some of the states in the South and in the United States, that is a problem, especially in the South states, but companies are already releasing information related to the climate impact of their actions, and investors are already making decisions based on their data, on this kind of data, trying to invest in companies that are more sustainable. That happened. I saw that in Dubai in COP last year, and it happened again. I witnessed that in Azerbaijan, and I was part of some debates regarding financial aspects. Now we have these new rules issued by the Securities and Exchange Commissions, and they issue that to accept a demand from the investors, because investments in carbon intensive economy will probably result in losses in the future, and it will become very expensive producing manufacturing products using fossil fuels. So we have they want complete data on emissions. They want information regarding risks in their investments in these corporations, and that requires sustainability reports that must be elaborated by these companies. And the final text was even more comprehensive that we had before, since we didn't have any information required in the past. So now these new rules implemented by the Biden administration, he's facing inflation, but his administration has been very positive in several areas, including with the Inflation Reduction Act and some other very important regulations. So these new regulations are bringing more possibilities for comparing different situations, and they are generating more reliability in companies' financial statements. This is already happening with corporations with the release of these reports. Investors are also considering now this information. And it seems to me that it's important to mention that those who defend the release of this information, in fact, are groups of what they call green investors in the US, and they work based on the idea of a profound decarbonization of the economy. So the companies have to address extreme climate disasters such as hurricanes and droughts, and they are even in these extreme events are interrupting supply chains and several other problems. In 2023, we observed 28 climate extreme events in the US, with a great financial loss and great changes in the environment. In the treasury in the states has been very much commented, though Biden has lost the election. Janet mentioned that climate change can generate a cascade effect in the financial air system in the US, causing losses. And I have mentioned that often in my speeches. Investing in pollution or accepting carbon intensive economy is something that will generate losses in the long term. You're not, because when you focus on that, you're not focusing on a transgenerational economy. You're not focusing on the future, the long term future of the companies. It is quite easy to understand that fossil fuels are less expensive if you don't have a price for carbon internationally as a general rule. Few countries are combining what carbon taxation with the prices. There are very few countries that do this combination. Michael Gerard mentioned that very much. These are the most important legal instruments to fight climate change and global warming. They bring advantages, but they also have bring disadvantages in the sense that are inherent to the use of these things. So it's important to mention that in the United States, even regarding the Democrats, which are the left wing there was many of them were against these regulations because of the financial incentives and sponsorship they get from the oil producers there. Another thing that was very important that was done in this procedure, the government opened for analysis by the companies, NGOs, and the society, and how that involves the corporations directly. Of course, the companies are complaining, especially the large ones, because they consider that's going to increase their production costs, that's going to generate higher costs. And of course, the Republican legislators buy that idea, that and they understand that this is really going to bring by higher costs. I think I'm running out of time. I'm out of time, right? Yes, you're running out of time, Gabriel. Okay, so that's exactly what I wanted to say. We'll have climate litigation because of that in the 11 states. Companies want to really fight against these regulations, but we do hope that Securities and Exchange Commission in the US continue to require information to make made available to the population. Publicity and secrecy are conflicting things, and they are going to now, and something that is, we're probably going to hear a lot about that regarding climate litigation in the US, with litigation in that area. And I think Donald Trump will probably try to dismantle the regulation brought by the Security and Exchange Committee. You probably have a big dispute there. Even the corporations that have supported Donald Trump, but you have the renewable energy companies that are investing for the future. We know that fossil fuels have a short life ahead of it. By 2050 or earlier than that, we'll run out of fossil fuels. So they need to find renewable alternatives. There are researchers in renewable energy growing in the last few years, and the corporations need to protect that research. So we have double-edged problem here. You have investors that want to invest in renewable energies and oppose the other regulations. So this is something that might be very important in the sense of having companies release information regarding greenhouse gas emissions and how that could generate climate disasters. So that will really affect corporations at this time. So this is what I wanted to say. I changed my speech a little bit. I'm out of my style, but I wanted to bring this to the debate here because in the United States, this is something that is being widely debated. Thank you very much, Gabriel. Thank you very much for being with us, for your speech. Thank you so much. Now let's move on with our event.
So I would like to ask Luis Omar Jr. and thank him for being able to be here with us today. It was a last minute substitution. He's going to bring a topic that was going to be discussed by Nicole Oliveira. He's going to talk about corporate licensing from the Arayara International Institute. Is interesting to note that we have two topics that are very recurring, topics that are related to climate litigation, that is civil liability and environmental liability. So thank you, Luis. He's a lawyer of the Arayara International Institute, member of the Environmental Disasters and Climate Change Commission of the Federal Board of the Brazilian Bar Association. He's a PhD student in law at University of Brasilia. And I would like to highlight something that is the role that the civil society organizations have been playing. We have traditionally a big participation of the public prosecutor's office in environmental litigation. And when we analyze the Brazilian society, we see that the NGOs have been playing a key role in the Brazilian climate litigation. So we have a big number of cases that were filed by the organized civil society, and the Arayara Institute has been behind the filing of many of those cases. So I'll give you the floor, Luis, and thank you again. And I think it's important to say this to understand the importance and from where you're talking about as the civil organized society. Good morning, Dani. Good morning, everyone at JUMA that I see here. I'm very happy to be here. Surely I'm not a perfect replacement for Nicole, but I'll try to represent her. Unfortunately, she wasn't able to be here with us due to health issues, but I'm sure that she'll be recovered soon and will be part of the next ones. Here in our webinar is also Fernanda, who's also a lawyer and the legal manager of the institution, and who also helps this all of our organization to run. So I'm going to talk about the International Arayara International Institute, but I think it's interesting to bring some information. So it's an institute that has been acting for over 30 years in the defense for just energetic transition, fighting fossil fuel use. So we can actually build an institute to defend life. Something that I noticed that many people do not notice, and it's always important to say. The Article 225 in the Constitution also attributes to the collectiveness the duty to care for the environment. So I think this shows that there's an objective responsibility in the culpability, and there is also a solidarity duty of all of us to do our share, and the yada yada does that in many ways, and I'm also going to talk about that through what we call 360 litigation, in which we fulfill many strategies in many situations. So we're going to talk a bit about some cases and explore more judicial litigation, but it's also important to say that the judicial litigation is nothing without the support from the sciences, from mobilization overall. But before going there, I think it's important to talk about two very interesting projects developed by the Institute that are the monitor of Amazon free from oil and gas and the ocean monitor. We can share that later in the chat so everyone can have access to it. They are a database that shows the areas that are being explored or that are being granted for exploitation. It's a very interesting database because it gives you information on what are the companies, and we can layer about conservation units, indigenous lands. We can add those layers to the database. It was built with a base of years of technical knowledge, and it's very much used in this litigation we do. Building this database, we were able to put this display and system so that any person can have access. It's very important. And getting into how litigation happens at Arayara, as I said, there are many perspectives and many hands that helped build this judicial litigation. So we have here a big team of scientists, of scholars that are specialized in their areas. And the challenge is to actually achieve all this group of knowledge, so we don't disconnect from the reality. So we understand there is an overload with judges, but we're very optimistic in the development of many projects. And I think I've mentioned to you, Dani, a few times, the importance of projects like JUMA. So we can actually synthesize knowledge and create movement that call the attention, that get the attention of the judges, of course, Judge Gabriel Wedy must have seen it, and also Rafaela. And we see that when we go and talk to judges, we see that they're engaged. We see they are participative, that a few years ago, it was not a reality. So if we talk about 2019, 2020, sometimes we filed an action, we would propose a measure, and it was even hard to explain what we wanted. And this paradigm was very hard to break. I'm not saying it's not supposed to be there, but sometimes it's very difficult to have a causal link. We had this idea that it came from a perspective, but it was connected otherwise. So we value scientific knowledge, and we see that it's from scientific knowledge that we can move forward. We have, in addition to knowledge, we have communication strategies. For instance, the National Oil Agency has auctions, and when they start planning those auctions, we already start understanding what's happening and organizing a campaign that includes the filing of public actions, but also communication and mobilization campaigns, especially in the day of that auction. So I don't prolong much my speech. I would like to talk about this first case, which is a very cool case, which is the Mina Guaíba, the Guaíba mine. Basically, they questioned the mine's environmental licensing. Arayara, along with the indigenous organization that was being affected, were behind it. And it's important to say that there are others that are now suspended, and this one was the licensing was annulled. So we had the indigenous component study, and this would be the biggest open sky coal mine in the South America. And there is a questioning that was successful, and the environmental licensing was annulled and it was dismissed. And I started saying that sometimes it's difficult to show that what we're doing there is not just mere talk and not just what ifs. We saw this year what happened at Rio Grande do Sul, the huge flood, and that this disaster could have been much worse. We had the company that was in charge for the mine. They showed a report of building the dam, and they made the containment system. They made calculations for disasters, and they had a projection and proposed they proposed the building a containment system that was, I think, 10 meters high. And with the flooding, that flooding would go over 4 meters of the worst hypothesis they were predicting. So we have a scenario that all the tailings, everything that would be deposited there would have been hit by the flood that happened. And these tailings would be scattered through huge areas, potentially hitting the city of Porto Alegre. And I think this shows and clarifies for those who doubt the importance of taking seriously the climate change. The result that I think many people are already familiar with, we're very happy. We don't litigate because we want, we do it because we need. And it is necessary, and when it works, we're very happy for this acknowledgement. The second case is a bit more embryonic. It's at an early stage, and something that has not been brought here to Brazil yet, that is the liability for climate damage to something that was licensed in an energy enterprise. So it's a thermoelectric plant in Paraná that is very old, from the 60s, and it's owned by Copel, that was recently being made private. It was a state company that was turned private. And it brings a series of elements that need further investigation. We're having a lot of difficulties in accessing information. And it is important to say how important transparency is. We have a federal law that provides specifically on access to information. And at times, the state agencies are very reluctant in providing information. In this case here, we're having trouble to be able to access this information, and it's absurd. The requests that are being made for those information. We were able to access some documents of these licensing, and we noticed that there was an environmental license, but it was from 202. It was from 2002, and there is a question that this is a very old enterprise.
But this was a project that received a license that ended in 2002 and was renewed in 2019. And the project has been operating throughout the time, breaching all regulations regarding pollutions and emissions. And I could maybe talk about that the whole morning, talking about what was wrong, but focusing on our point here, what we build there. And once again, using a lot of the work Dr. Rafaela talked about in her PhD thesis concerned about the liability for climate damage, we built that thesis that, okay, they received a license. We don't agree it was not the way it should have done. But from the point you have a license, you had conditions, there was an authorization from the government for the project to operate. It continued with emissions higher than the limit, the threshold set. The license didn't happen, and the company must be held accountable for the climate damage that occurred with no prejudice to the damages caused to the soil, to in atmosphere pollution. And then, Danny, I do agree with you 100%. I think climate law is a kind of a branch or a leg of environmental law, and it's advancing to become a whole body of it. But as an attorney, it is important to observe this theoretical debate for it to become uh, really a branch of environmental law, so we can take advantage of the entire path that has been built in that area. In this procedure, our actions were not granted, but we got into a process of conciliation. We are watching that in the Supreme Court very often. The procedures we are able to follow, I think all the audiences, they are calling those monitoring. We have, as Dr. Gabriel mentioned, we have some actions regarding the forest fires. And another case I want to mention is this trend of creating a conversation, a dialogue with the corporations. And in the case of Figueira, the government was willing to have a conversation, though the corporation didn't want to proceed with the conversation, but the government appeared to be willing for that conversation. I would be interested in having that kind of conversation. They are solidarily accountable for that. So I think that is something important for us to keep in mind and think about. The other case I wanted to bring you regards another exploration of oil and gas in the state of Santa Catarina. We had a public procedure a little bit before the licensing process, in the offer process. This process operates under a different logic. They required a minimum social environmental study before the offer. We would need a greater study about that. We know that that doesn't happen, but there should be a social environmental analysis regarding traditional communities and environmental risks for those offers. But they offer this area. You have the map here on the right, where you have the checkered area. This is an area for oil and gas exploration. And the area where you have the horizontal lists is the community of Rio dos Patos. And our argument was that you're offering an area for exploration. We always ask, really question that. They started to cut through indigenous lands, and you had this overlapping, and they would say, well, now they can do that. And we said, well, there is an area of direct influence on that indigenous lands, on those indigenous lands. It was a risky thesis because we were focusing on the concept of environmental licensing, but it worked. We won. They acknowledged the need for previous informed consultation with the community before signing any administrative action that would consolidate the granting of that area. And all that is related to licensing. It doesn't mean they are conducting the consultation in the environmental licensing process. They would have their own process for that. But this is a very interesting case because we have taken concepts from environmental license to a prior phases. because we understood and we're very fortunate to be able to make them understand that, because even the beginning of the project would bring a lot of people into the area and that would affect the life of the community. So in this case, we started asking, requiring that the government would act, and we are hoping that they will really side with us because we had a very positive impact. The other case, it's also a recent one, regards a public action we had in the state of Rio Grande do Sul, and it's something that occurred after the disaster we had, and which focuses on energy transition. This litigation did not arise but became a corporate litigation process, because one of the debates we're having is that the government was conducting an energy transition plan, but they decided to outsource and privatize that plan by hiring a private company through a bidding process to build the energy transition plan. And in our opinion, they did not observe a very important and basic principle of energy transition, that is the participation, the social participation aspect. And any transition will heavily affect the community, and the community will have to go through challenges to requalify, to retrain, to adapt to the new economy brought to the area. And this became corporate litigation because one of the first actions was suspending the contract and implementing a work group involving academia, the government, and private sectors to debate an energy transition plan. And why did we start with this procedure? We have previous experience with energy transition in Brazil. I know I have gone over my time, but I'll get into the last case here. I promise I'm moving towards an end. We have a federal law, the 1492, and a state law, 18330, from the state of Santa Catarina, versing about energy transition, especially ADI 1795, focusing on federal law. They debated a little bit about that. It was one of the first cases that questioned an energy transition legislation. I'm sorry that it doesn't focus on licensing, but it focuses on corporations because it brings an express authorization for contracting thermal electrical companies by George Lacerda in the state of Santa Catarina. But I thought it was important to bring this case because one thing we take from corporate climate litigation are the lessons learned. And we see that these two legislations that were created without social participation did not work. And in these two specific cases, what happens is that they have created this federal legislation intending to create a phase out of coal by 2050. They use the justification of the phase out to renew authorizations for the thermoelectrical complex of Jorge Lacerda up to 2050. And they thought we would not notice, and included subsidies for coal that can be used, subsidies that can be used. That they thought we didn't notice, but we did. We wouldn't notice, but we did. And it would prolong by up to 2050, and that's where the funds would come from to pay for the code used in Jorge Lacerda. So the code, you see that the consumers pay 100% of what used, and the code is paid for the government. And we have several studies from IDESC and all that, proving that without the subsidies, coal would not be financially feasible. The math doesn't match. So what we have done with this movement was we analyzed the legislation, we talked to the participants, to the parts that would take that to the Supreme Court, and we were able to go against these two legislations, 1795, which is federal, 7332, which is state, and we see that the state law worsens what was there in the federal law even. So they reduce the accountability of the co-producers in the state. And I don't believe it's a coincidence, but we see that the owner of the complex itself was received benefits in the process. So unfortunately, we open a greenwashing energy transition case. So it's very bad. They have a energy transition plan that works as a front. And anybody who doesn't read the legislation carefully will notice that a policy for energy transition under those characteristics would not work, and it wouldn't even foster thermoelectric energy plants. So we really had to work on that. We still don't have any result from that, but we saw a very important movement to that sense, with some manifestations saying that this is unconstitutional. So we are waiting for the progress in these processes. This is basically what I wanted to bring to your attention. I want to really thank you for the event, for the work you're doing. Arayara is one of your biggest clients. This is something I'd like to say. So I hope we continue working together. It is a great pleasure to be here, and I thank you for the opportunity. I leave you with our contact information, our social media. If you want to contact us, please feel free to do that. And once again, thank you for the opportunity. Thank you, Luis. Your presentation was great. It brought a lot of information about such cases that are so important. So it was great to hear you. I'd like to make a couple of quick comments based on your speech. One of the cases was of the thermoelectric plant of Figueira, and you mentioned the request for reparation for climate damage. And considering the context of corporate climate litigation and the profile of climate cases in Brazil and greenhouse gas emission cases in Brazil, as Carolina mentioned in her opening speech, this was the first case that brings together arguments regarding civil liability for climate damage, requesting a calculation of the climate damage and environmental climate in the energy sector. All other civil liability cases for climate damages that require a measuring of the damage and a compensation for the climate dimension of the case have to do with deforestation. This was the first case that brings in arguments related to environmental climate with a special focus on that area regarding the energy sector, which is very important and interesting in the context of climate litigation in Brazil. And another thing that I find interesting, and I wanted to comment regarding the profile of corporate climate litigation, is that the cases of environmental licensing involve the government as defendants. This is a characteristics of corporate climate litigation in Brazil that it focuses on environmental licensing. Since the public power is the one that grants the licensing, they can be brought together as defendants in the same area, bringing together the private and public sector. And I think these cases that you have presented and some other cases that have the same profile, they're very interesting in that aspect. So it was very interesting to hear you about that. So thank you for being with us. I think we can open for a few minutes for a few questions. We have a question in the Q&A and another one in the chat. And I'm going to read them for you and direct them, okay? First question was from Fabiana Medeiros, and she asks, good morning, Luis. About the first case, in what phase was the licensing? Was the action proposed only based on the EIA? Luis, and I'm going to bring another question together to that so we can you can answer both of them. The other question is, have you, from Luciano Tse, have you noticed any kind of difficulty from the judges or representatives of public agencies who are part of the case in understanding the obligations and regulations regarding the climate that are used in the case? Is this a difficulty in the progress of these actions? And I'm going to give you the floor to answer them. First, thank you for the questions. Thank you, Dani, for that. First, I think the question is regards what time we started actions. It was when we were starting public consultations. And in that sense, it's important to observe the behavior. And I think that what happened at Guaíba says a lot about how project owners see the EAI in Brazil. I have participated in an instance regarding environmental license, and there was an article specifically regarding on accomplishing that. In Guaíba mine, it was very a good example in the AI Prima regarding that. When they realized they would have to conduct a study on the indigenous team, they took something that was huge and said that they were going to bring everything together. And what the response they had was, for you to have an actual understanding of the impacts the project may need to have on that community, you have to start from scratch. All your studies have to have synergy and have to include the information you have on the area. And it is very rare for something like that to happen. We work in other large EAI cases, but to answer your question directly, we already had the EAI under development. And we started this action specifically. We started from the analysis of the EIA because the project owner said there was a community there. And also we had studies done by Arayara itself to show that the community was there, or showing the impact area and how that would affect the community. I hope I have answered that question. If I did not, please let me know. In the second questions, I can read it here. With regards to the difficulty of public agencies regarding climate regulation. As I mentioned, yes, we have observed some improvements, and I want to highlight the work you have been doing, and in the sense of spreading this information and summarizing this information. When you are on the eye of the storm, you don't see what's happening. And the work of summarizing and telling the story as you do is extremely important. Unfortunately, we see that it continues to be a judge that will, or a public worker that understands things the way we understand or the way we see the importance of the sim is a rare thing to happen. But another thing that is important is the use of regulations that have been internalized in Brazil. And it's important to mention that we talked about what happened after the decision, that was the acknowledgement of environmental treaties as human rights treaties, as we saw for ADFP 708, and the acknowledgement of the supralegal nature of these treaties. And for those who don't know that, what that means that that international treaty is more important than local legislation, but it's under the Constitution, so it cannot have a federal law that goes against that treaty. So there is some difficulty in understanding and processing the entire information. Many of the actions in the green agenda will bring this international aspects focus on climate, and that opens possible paths for cases such as others in which Arayara worked. And I saw something you had never seen. At that specific case, we were at about the end of 2022, if I'm not mistaken. ADPF, the first one that was judged was ongoing. We had a vote from Minister Carming acknowledging the nature of the thing, and the sentence rules on that. It's still ongoing, but it points, based on the context, it's going to be acknowledged, and the judge builds a whole argument to say that, yes, we needed to include in the environmental license emissions. I'm talking about talking so long, but I do see there is still some difficulty. There is great concern in the case of the projects. I have not seen an oil and gas company with economic argument that says, oh, we are going to have great loss, we have energy losses in that. We are working to make our arguments more sophisticated because we know the kind of arguments we're going to have to face again. And a short while ago, we wouldn't be able to be talking about many of these topics. Thank you, Luis. We have another question here for Maria Eduarda. Maria Eduarda, how would you say we could contribute as a society to understanding and effective use of the protocol for environmental action judgment from the players in law? Thank you for the question. Protocol is a very technical document, and it is a guidance for courts to analyze and judge procedures. And it has two scopes. The ones regards actions regarding remote sensory, and lately, more recently, we had environmental licensing, damaging. And we were debating how the courts could handle and deal with topics such as this. But although it is a specific guidance for courts, as a legal practitioners, you need to understand those guidelines, especially when you are elaborating any procedure piece. You can consider those guidances because then you have the basis that are considered officially by the higher levels regarding those topics. They use a methodology from the Association of Members of Public Work for the Environment. It's an association of the civil society that has been very active in climate litigation. So they use this mitigation from the civil society that is also based on a carbon emission calculator created by IPAN. And they use that to calculate emissions resulting from forest fires and deforestation, and the amount calculated by each emission. It's very specific, it's very technical, and as we said, is that need we have to link science with law. And when you talk about climate change, all the scientific and economic aspects that we are mentioned are very relevant. It is not a very long document, but it's very technical. So thinking about really spreading this protocol and what it brings, maybe we might have a study about the protocol and the use of the protocol in a language that is easier to understand for the layman. So that can be used as a guideline. So we have a technical basis when we are creating the action, so we can have easier conversation in the courts and while structuring the process.
Thank you, Maria Eduarda. I just want to make an observation about what you said precisely on the profile of the climate cases in Brazil, dealing with the dimension of environmental damage. There is a great discrepancy in methodologies. So it's also due to this difference that led to different results, both in the calculation of the amount, the carbon amount emitted, and also the carbon value per ton. So there were different numbers that generated different results in this calculation, and it was very important to bring this work group in a few public audiences that resulted this protocol that was brought by Maria Eduarda in cases of damage to the flora. And it was very important to minimize and overcome this hurdle, this methodological hurdle to identify damage. Thank you, Maria Eduarda. I'll ask one more question for Luis, and then we have another question. Luis, this question is from Renata de Loyola Prata. How the different elements of campaigns, advocacy, communication, scientific production, mobilization, contribute to the victory in judicial actions? Well, I think that we're talking here generally about proceedings that will bring a social and economic impact that will usually be very high. So I'm speaking from a civil society place. So the public prosecutor's office, for being the holder of the actions usually, from the point where the organized civil society actually does get organized and starts acting more in these public civil actions. there is some reluctance from the judiciary power. So what does this organization want with us? Who are these people? We read this between the lines. Some questionings on active legitimacy, even though the actions are very objective. Some dismissal of evidence. So if you see the case as a whole, you can notice when we litigate, for instance, at an auction, a gas auction. So in the last year, we litigated 70 blocks that started end of the last year, but they're still ongoing. And we had at least 6 oil companies that have a capital that is not matchable to our movement. So it's important to have a communication planning, a mobilization planning, and say that, see, we don't just want to get an injection to have a nice image. We want a change that is starting to become real, and it's just a part of a much bigger action. We're going to put ourselves on the line because from the time where you have a technical appeal, it's going to have criticism. So for instance, this last auction that Arayara had a campaign and called the end of the world auction, we had that part in the auction. And once I wrote an article with Nicole talking about the extra procedural effects, and that litigation is not just the judicial proceeding. For instance, there were some specific areas in Fernando de Noronha that there were no tenders, and that's a huge win. And you can say, oh, okay, they're talking about it, but maybe this would happen anyway. I think that in the 4th round, this was one of the bigs. The guy that was there representing the company said, the company used the student studies you made, so we don't have an offer for any of those blocks that you're talking about because we don't want any problems. So we have this litigation advocacy communication. It's key. It's key so the legal litigants works. Thank you, Luis. So I'm going to ask one last question for Maria Eduarda, and then we can move on to closing. Maria Eduarda, it was mentioned that the causes of to ask in corporate climate litigation in Brazil include environmental law and human rights. When we were speaking and throughout the debate, there was the question of the relation between environmental law and human rights in the country. What's your opinion on those two bases for cases? Thank you for the question. It's a topic that I am very interested on, the relation of human rights and environmental law. And different ways can be mobilized for this climatic corporate litigation, both in environmental law and human rights. I can give you some examples as Guaíba mine that was beautifully presented by Luis. There is a point of the consultation that was made to the indigenous people before licensing. Many cases, there's the installation of the project without licensing, and the people, local people that are there, are not respected. So the way of life of a community that many times is close by, culture, food, water sources, is many times impacted by that plant. And that is also related not just to the environmental question for the impact, but the impact, the environmental impact itself at that location. And as I said, the way of life of that community. And I don't want to talk much, but it's something that I find very interesting. The historic concept of environmental justice itself derives from the movement of environmental racism, uh, the, the installations, the garbage facilities in the United States that had a question of financial resources and were predominantly Black. And to sum up, it was how, very briefly, just to explain how it came, this movement of environmental racism. So we have those polluters of high impact that are close to the community. And we see that in relation to indigenous peoples, traditional communities. And there is also the moment of actions on the carbon voluntary market, in which some areas are separated and they don't consider the populations that are there. There are in that territory. And due to the restrictions of that territory, many times they cannot carry on their way of life, their cultural practices. So they're not seen, and many times they are pushed away from that territory due to a project of carbon market. And we already have a few cases here in Brazil that are dealing with this topic. And I think that we can link broadly human rights with environmental law. Since the Stockholm Declaration, we have this connection of all cultural and social impacts. So many times when you're causing an impact on the environment, talking more restrictively, you're also impacting the health of a population. And also another example of this very strict relation is how the climate change organization is moved by young people, not those that are here, that are already born and already filing many actions. We have national, international examples, but also it's a cause of those who are to come. So we need a planet that's going to be inhabitable for those who are being born. We also have a point in Article 225. It's very used for that. And there is a big potential in this link because the environmental law itself talks about that. Thank you, Maria Eduarda. Thank you so much. And I think now we can move on to close the event. I'll give the floor to Carolina, but I just want to make an announcement that we had a problem with one of our panelists, that was Mauricio Terena, indigenous lawyers, that was going to talk about corporate litigation in Brazil from the indigenous people view, but he had an emergency that unfortunately he couldn't be part of our webinar. So I just wanted to communicate that to all and thank everyone who's present, all the panelists that contribute to our conversation. And I would like to call Ivano if he would like to make any final considerations.
Thank you very much, Danielle. Thank you very much, everyone, for joining us today and really for contributing to such a rich discussion. I think this is going to be really helpful for the development of the project. We really try to use all this information, this exchange also to improve the global toolbox. And of course, a special thank to our speakers for sharing their expertise and also to everyone who worked behind the scene with the translation and to make this webinar possible. There is one other thing that I want to add. As I mentioned before, in February, we are organizing the American Summit in Washington, D.C. as a hybrid conference. And of course, we would be delighted to have you there as well. So we will let you know the details about this. But anyway, this will be also in collaboration with Danielle and Carolina and the Brazilian group. So thank you very much, everyone, again.
Thank you, Ivano. It was a pleasure. So we're launching the executive summary and consolidating our partnership. Carolina, I'd just like to make my final thank you. I think this event was a success. We were able to fulfill what we planned, joining many sectors, the academia, the social movements, all of these views of corporate climate litigation, and many of the facts that are in the Brazilian report, but also in the executive summary that is being launched today in Portuguese and English. So I'm inviting you all to download those materials. There are many topics and many other topics that we were not able to talk about today, including the very important ones that were discussed today. And thank all for your participation. Thank you, Carolina. I just would like to complete and say that our studies at JUMA have been published. We've been able to publish some of them. So if anyone is interested in a view of the climate litigation in Brazil in general, you can access the report and the bulletin that's going to be launched in 2 weeks, the maximum. So we have material in Portuguese and English too. This is about the 120 cases that were registered in the platform until October 2024. So I just wanted to say goodbye to all and thank you all once again. I would like to thank the interpreters. I know it wasn't very easy because we ended up talking a bit fast, but it's not very easy to speak slowly. And thank you for your availability to be here with us, making this effort of interpreting. And thank all the researchers at JUMA that were here and everyone who's here watching. We're going to make this video available at BICO's website, right, Ivano? And so thank you so much, all of you. Have a nice weekend. Bye bye.